Morning.
Good morning.
I'm here with one of our lawyers, Jasmeet. Jasmeet, would you like to introduce yourself a little bit? Tell everyone about your job, about what you do, what you have done, what you're going to do.
So my name is Jazz. I'm one of the associate lawyers here at Axess Law. I work out of our Ottawa office currently, which we recently launched. And I mostly do wills and estates and also handle real estate matters. I also assist Lena with a lot of research on certain topics that we are also going to discuss in this video as well.
Wonderful, thank you. And thanks for your time this morning. I know we just decided to do this last minute in response to the emergency order that came out yesterday. So thank you for your time.
Oh, no worries. I think it's good that we get some clarification out there on the order and some background as well.
Absolutely. Okay, well, let's jump right into it. So, Jasmeet, maybe you could start by giving us a little bit of a background on before all of these, emergency orders came out, before coronavirus. What was the state of affairs? How were wills being executed? What were any obstacles that were in place that prevented people from being able to sign or execute or witness wills virtually? If you could give us a little bit of context to start.
Sure. So the wills and estates is mainly governed by the Succession Law Reform Act. And that basically stated that there's a requirement that two individuals witness the testator sign the document in their presence. Now, the issue with getting it virtually signed at the time before the coronavirus was that there was no interpretation of in the presence and what it meant. So whether that required physical presence or a virtual through audio video conferencing. Now, due to the coronavirus, that has changed. But before then, it required people to physically meet and sign the document together with the wet ink signature as proof that they were all together.
Okay, so just to summarize, lawyers were essentially erring on the side of caution because there was no interpretation available for signing in the presence of someone. So therefore, lawyers, including ourselves, decided to interpret it as physical presence because the last thing you want to do is take a liberal interpretation of something and have our clients be at risk or have procedural issues.
Exactly. That's correct. Yeah.
Perfect. And just to give a little bit more background, we've had at Axess Law, we've had a working group for over the last year where we've been looking into these items, and Jasmeet's been leading it up. So he is pretty nearly an expert in this area.
Yeah, we looked at various jurisdictions, saw some interesting case law from Ohio and all over the world regarding virtual witnessing.
That's great. So basically, we're talking about the Succession Law Reform Act. In one sense, was saying, look, you have to sign your will in the presence of a witness, two witnesses, and we also have the commissioners for taking affidavits oath as well, right?
Yeah. So that act is basically for statutory declarations or affidavits that are being sworn. That also had a similar language which said that it required the individuals to be in the presence of the oath taker. So again, it came down to whether that meant virtual presence or physical presence, and lawyers erring on the side of caution, of course, went towards requiring physical presence from clients and individuals who had needed affidavits sworn.
Okay, perfect. Okay, so that's been the state of affairs. I know that we've been looking into that for the past, as I said, over a year. And we have been virtually having meetings with clients. We've not been obviously executing documents virtually, but we have been having meetings. And the reason for that is because we have 7 offices across Ontario, but they're really in the GTA, they're in the Ottawa area. What we've found is we've just been inundated with requests from people from other parts of the province, whether it's northern areas where they just don't have access to be able to come to an office. So we were able to draft their wills, but the execution was always an issue for us.
Yeah, exactly. So one of the biggest questions I would get at our offices was when someone came to complete their wills, they would ask, well, do you have an office in Hamilton or do you have an office in Timmins? And well, we didn't have an office at the time, right? But now, due to the evolving virtual practice, we are now able to serve clients everywhere. But one of the issues was that we weren't able to get the will signed, or we would have to get them to go before a notary or arrange 2 separate witnesses to watch them sign the documents.
Now, of course, that's not the ideal situation. You want to be able to execute your will with every single client. And obviously, we had safeties in place to make sure that we followed up and ensured that they were executed properly. But that by no means is an ideal situation. I think, again, to give a little bit of context, we're dealing with 56% of Canadian adults who don't have a will. So the option is either allow them to not have a will or figure out a way to have these wills done in as frictionless an environment as possible. So I think that these new orders obviously have come about in an area of, or of a time of, incredible challenge for everyone, but hopefully they do have lasting effects. And it is, they are allowing people to have these documents drafted who haven't had that option before. So maybe, Jasmeet, could we sort of fast forward to, that's what was happening, to first emergency order. What did that allow people to do?
So let's just start with where it began from the Law Society, interpreting the Commissioner of Taking Affidavits Act as presence, meaning virtual presence. So that was the first step in allowing virtual witnessing, in a sense, because now people could swear affidavits as we are speaking like this through video conference without any issues, right? Without any worries that it would be interpreted as not binding. Fast forward a few weeks later, the Attorney General, which I want to thank because they acted very quickly, enacted a emergency order allowing for wills to be signed virtually. Now, virtually, they still required that there was a wet ink signature on the document. So what the order required was that the document would need to be seen by the first the witnesses would see the testator sign on video conferencing, and then the testator would be required to send the document by a courier to the witnesses. Now, if the witnesses were together, that would work very well because you would only need to courier at once. However, if there was two witnesses at two separate locations, then it would need to be couriered to one witness first, where then they would sign that same document the testator signed in the presence of everyone again through video conference, and then it would be couriered again to the last witness, who would then do the same process of having everyone watch them sign. Once that document was signed, you would compile it, and then you could send it back again to the client. So that was a good workaround while incorporating social distancing. And that was the first part of allowing virtual witnessing of wills and power of attorneys as well.
Okay, so great step. I guess the main obstacles that sort of I've heard from lawyers was, look, this is excellent, this is much needed, but it does still require a number of couriers. And if the client doesn't have a printer, we're in trouble. Sometimes we're printing the documents and sending it to them. So it's a bit time consuming, and it's a lot of work. And the problem
it's not very,
sorry?
not very cost effective either, right? In a sense that it requires quite a few couriers. Also, couriers are operating at limited hours themselves now. So that makes it much more difficult to get the documents around. And if it's an emergency situation, the document, you still need a few hours to get everything executed. And that's if everyone is available to immediately sign after the first session.
Okay, great. So I think what happened then is they looked at the order and they said, this is a great first step. Let's tweak it a little bit to see if we can address, the necessity to have a number of couriers, which just, isn't practical right now, nor is it cost effective, as you mentioned. So fast forward to yesterday, I think it was actually signed the day before, but yesterday seems to be when the news broke. What happened in this latest emergency order?
So the latest emergency order tweaked the virtual witnessing process, allowing for signing in counterparts. So what that means is now lawyers and their clients can do is print out a copy of the will after they've gone through the process of drafting it. And all three individuals will have one copy which they sign in the presence of each other, of course, over video conference. And then those three documents together would form the single will itself for the client, or power of attorneys as well, of course.
Okay, perfect. That's great. Now I'm going to ask you a tough one, and I know you've had only 24 hours to actually consider this, if you even have yet. What does that mean for lawyers? What do we have to draft differently? Does the jurat need to be drafted differently? Do we have to draft the affidavit differently?
So the attestation clause needs to be tweaked a little bit as well. at the bottom where it says signed, subscribed, and published to take into consideration the process and the three separate wills. And also the affidavit of execution will need to be updated and tweaked to allow for multiple exhibits to the affidavit, because now there'll be 3 copies.
3 copies, or I guess 2. If,
Yeah,
for
2 or
example,
3.
yeah, if you have a witness in the office,
Exactly.
for example. Okay, perfect. Okay, so two places, two things, 2 main sort of areas that lawyers need to pay attention to, if of course they're doing an affidavit of execution, would be the affidavit of execution itself, as well as the jurat or the attestation area, correct?
Yeah, correct, yeah.
Okay. And practically, can you run through this for me? So let's say, for example, I'm the client, you're the lawyer, and we have a third witness somewhere else.
Yeah.
Okay, how are we going to do this? We're meeting right now. We're done our appointment virtually. We have our will. We've reviewed it. It's time for me. I have a printer here. You have a printer there. Our witness has a printer. We're all going to go print our documents. Can you run through this for me? How does this work?
So the first thing would be, of course, to print the documents and hope there's no issues there. Once the documents are printed, every party would first have to watch the testator sign. So the two witnesses would watch the testator, which is the client, initial the first 6 pages of the will, or however many pages there would be, and then sign the last page. Once they've completed that, then the process would move to the next witness, and the next witness would have the same printed copy of the will, and they would physically sign it as well on their copy, and then the other witness would do the same. And then there would be the 3 documents. Afterwards, what would likely be required is that we would have to ask the testator to courier the documents to ourselves so that we could compile it, put it together with the affidavit of executions, so that they have a will that they are not confused about, right? Because if we just send everything to them, they're going to wonder, how do I put this together and things like that. So we'd have to compile it together and then mail it out or courier it out to the client so that they have a copy of a fully executed will.
Okay, so assuming we take the position that we are going to compile the will for them, that we can't sort of give them appropriate instructions to do it themselves.
Yeah.
Would require 1 courier from the client to, let's say, our head office where you are. 1 courier from witness to head office.
Yeah.
So that's 2 so far. Now you're compiling it, and now a 3rd courier to the client once you've compiled it, right?
Yeah.
If we take the position that we can give the client the option to compile it themselves, and we're able to provide them with appropriate instructions for that, it would be 2 couriers, 1 from you to the client, 1 from witness to the client.
Yeah, so that is another option. We could definitely courier to the client themselves and have them compile it depending on their sophistication level. Or we could also video conference and go through that with them as well in a final session to make sure that everything is put together correctly. Okay,
perfect. And I guess best case scenario is you're sitting in the office with a witness and you're able to put your 2 actually, you would only have 1 copy and send it over to.
Yeah.
Now, question for you. I'm going to play devil's advocate for a second. Do we have to send them to a client? Could we keep our counterpart in our will bank? We have a large will bank of a lot of executed copies of our clients' wills. Could we simply keep them here and treat it as a true counterpart where they have their copy, we have our copy? Or is that bad practice?
I think that would be bad practice, because all the wills together would be considered the single will itself. So I think it's a good idea to keep them together in case the client, as we know from our experience with probate, documents do get misplaced, and we want to avoid that as much as possible.
Great, that was a trick question.
So what we need to do is make sure they store it with us.
Exactly. Well, that's actually a good point.
Yeah.
Okay, that's great. So, okay, so I just in summary, it sounds like the provincial government has made some excellent strides. I'm really happy where things are today.
Yeah, I definitely applaud the Ministry of Attorney General for moving so quickly to get these emergency orders passed. And it's really made our life easier, right? When talking to clients, they have concerns themselves. They don't want to come into the office. They want to practice social distancing. And these are a good step. This is a good step in the right direction.
Great. So if we were to push it a little bit further and say, okay, what about all those clients who don't have printers? Now, at Axess Law, we are really fortunate that we've been collecting data over a number of years, and we've been keeping data on clients, whether they have printers or not, over the last, I think, 15 months or so, just because we've been doing a lot of these virtual signups, virtual meetings. Never signing, just meetings. I was thinking of real estate there.
Yeah, mix it up.
Didn't mean to scare you. So the data that we have, and this is our client base, but you know, the sample size is large, it's over 10,000 clients. We have found that a little over 45% of them do not have printers at home. So do not have printers at home, do not have printers with ink at home, do not have a working printer available to them. So that's an issue. And it's a significant issue because if we're dealing with, you know, again, 56% of the population who don't have a will, and of that group who come here, 45% are still having trouble because they don't have a printer. I mean, I suppose we could mail them a set of documents. There are still tweaks that could be made. Could you speak a little bit to, and I don't know if you know the ins and outs, so I'm happy to jump in as well, Jasmeet. New York is one jurisdiction that's done some interesting things. I know there are others, but it's recent. What else could we do to help sort of smooth out these other obstacles that people are running into?
Yeah, so let's just focus on the U.S. and what different states have done. So prior to the pandemic, I believe it was Nevada and Florida have both allowed electronic witnessing of wills and full electronic signatures on those documents. Now they have put in safeguards. I don't remember them off the top of my head of what they require for the signatures. However, you do not require a printer, which takes care of that problem. And there is no requirement for couriering of documents back and forth either.
And you may not know the answer to this either, but I'm sure there have been issues, like there are issues with wet ink signature wills. I mean, listen, when money is involved, there are always going to be issues. But have they seen a lot of issues stemming from this legislation in those states, as far as you know?
So far, I haven't seen anything regarding issues from the electronic signatures. I think it's still a little early because it was just recently enacted, and as we know with wills, it's time for these issues to develop. But from my perspective as a lawyer, the most common question people say is, well, how do you know someone's not forcing the individual on the other side to do something, right? Well, that applies in person as well, because there could be someone in the car waiting for that individual when they come down, right? So it's a difficult thing to judge, and we do our best, right?
And I would agree with you. I think that most of the objections that I've heard in the past deal more with how do you assess mental capacity? How do you ensure that it's the person who it's supposed to be, who's on the other side of the camera? And how do you ensure that they aren't under duress? And none of these things really speak to whether or not electronic signatures should be able to be used, right?
Yeah.
Is it any more risky if we're sitting here having our video conference and taking instructions, for instead of me printing it out and signing it in front of me, for us to open up, you know, one of the various softwares that are available to us, use my touchscreen device, sign my signature.
Yeah. I mean, there's been some interesting case law all over the world, right? There's been cases where there's been wills that were found on hard drives unsigned that have been accepted for probate. And there's been people who have scratched their wills into tractors and things like that that have been accepted for probate. So I think the wet ink and strict compliance, although it does have good safeguards and it does protect the testator themselves, I think it's a little outdated, and it definitely needs to be updated.
That's great. I think these are all really interesting issues, and I think it would be useful to look at some of the other jurisdictions as well in the future. You know, the UK, New Zealand, Australia, certainly different states. People are doing it differently all over the world, and we can always learn something from what they're doing. But I really appreciate your time this morning. This has been very interesting. Things are rapidly changing.
Yeah,
it's nice to be able to just stay on top of it.
It's been great that there's been so much change so quickly, and I think it will better the profession overall and allow us to prepare for the future as well. One question I have for you, Lena, is do you think that these changes will stay in place after the emergency order has been lifted?
So I don't have a crystal ball. I'll start with that. But if I had to be a betting woman today, I would say I'm not inclined to think that they're going to retract this emergency order all at once or quickly. I think that people get used to doing things a certain way. They start to see what the advantages are. I would hope that what would happen is it would stay in place for certainly as long as we need it. And it would give us the time to see how it works, see what the advantages and the disadvantages are, and use that learning to make some permanent changes to some of this legislation like the SLRA. So certainly I'm not saying let's take the emergency order and copy it verbatim into new legislation, but instead take it, learn from it, figure out what works, what doesn't work, take whatever amount of time is necessary and use that to tweak legislation. Do I think that's going to happen? Yes, I actually do think that the Attorney General's office is very motivated to try to, assist people in various access to justice realms. And I think that they're interested. I think that their attention is on this matter. So a lot of this comes down to us as a profession really taking the time to not just do what we can do, but also look at it and say, okay, how would we like this to look in a perfect world? Let's put our heads together and communicate this to the people who are actually making the rules, because we're the best people. We're the best people to be able to provide advice on it because we're doing it all day long. We know,
Exactly.
we know what the obstacles are. We've done over 100,000 wills and we have really seen, okay, this is a problem, this isn't a problem. So I'd love to be able to continue, the various working groups we've been a part of and really make some permanent changes.
That's great. That's great. I completely agree with all the points you made there. And I would just like to add on the like making it accessible to other communities. I think that's very important, right? Ensuring that individuals are able to do their wills no matter where they are. It better prepares the world for future pandemics as well.
That's a great point. And, on that note, I know that there were working groups in the past addressing various fly-in communities in Ontario as well as in other provinces. And other provinces sometimes have more of an issue with this, but they have a hard time getting a commissioner of oaths up there. It's really difficult.
Yeah.
And, we should be able to address this in 2020, right?
Yeah.
Great. Thank you so much for your time. Have an excellent Friday and weekend. And we will hopefully have another session soon where we have more updates.
Sounds great. It was very nice talking to you, Lena. And enjoy the rest of your week.